Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about lawyers being suspended. Cases that should have gone to the Supreme Court of Canada, but didn't. An individual in Nova Scotia was subject to a number of complaints as a result of allegations of incivility and conduct unbecoming a lawyer. While the investigations were ongoing, the Nova Scotia Bar suspended this lawyer's license in the interim, prohibiting him from practicing law until the investigations were concluded. He challenged this, arguing not only that ultimately the decisions on his allegations of misconduct were incorrect, but also the decision to issue an interim suspension of his ability to practice was inappropriate. And this case raises very important issues. There are a lot of regulatory bodies for professionals in Canada, and there are a lot of regulatory bodies in Canada that are being taken over by government. And when it comes to people who are members of a regulated profession, if they are suspended pending the outcome of an investigation that could ultimately be determined in their favor, that is the end of their ability to earn an income and ply their trade in the meantime. And these investigations aren't subject to any time limits. There aren't rules about how long they have to hear these cases like there are in criminal investigations where the courts have to decide the case within a certain amount of time, or you can argue that your rights were violated. A person could potentially be without the ability to earn a living for years while an investigation is underway. To give these law societies and other professional regulatory bodies an unfettered power to suspend licenses pending the outcome of investigations, this could lead to a significant unfairness, particularly for people who are the subject of spurious or unfounded complaints. The Supreme Court of Canada should have recognized the broader implications, not just on this one individual who ultimately was found to have committed misconduct, but on regulated professionals as a whole. This could mean potentially taking doctors, nurses out of the workforce. It could mean taking accountants, making them unavailable during tax season. These are the types of things we want to avoid. And although there may be circumstances in which an interim suspension is appropriate, there should be clear and tight guardrails on allowing professional regulatory bodies the power to impose these interim suspensions. And a bald allegation of misconduct that it's disputed without evidence of a potential harm to the public shouldn't be enough to permit an interim suspension. Hopefully the Supreme Court of Canada has another opportunity to restrain the power that professional regulatory bodies have over their members, and to do it in a way that makes sense and protects the public, as well as allows them to continue to service the public good. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazenbull Creative for putting together these videos. Please like, subscribe, and share with your friends.